Welcome, everybody, to Immigration Impact Litigation's weekly update. I missed the last couple of weeks. I'm sure you guys plodded on as best you could without my superior technological capabilities.
Only missed one of the two because of that.
Yeah, it's not bad. That's not bad. But it's good to be back. And I think we need to kick right off with some information on the 601A litigations. Let me find our handy dandy banner for this. I know I have it here somewhere. There it is. Our joint litigation with Ayla. Because we have a couple updates about things going on. But the first thing I want to mention, there's a great Facebook group that a lot of our plaintiffs belong to. And people started popping up in the last couple of days that their cases have been transferred. Greg, what can you add to that?
We have had 40 transfers on... Was yesterday the 13th?
Yes.
Yesterday was the 13th. 40 cases were transferred on the 13th. We had a kind of a lull in activity for about a week and a half, which was not great, but it seems like they woke up again. So that's good. We, obviously we want the approvals, but we're happy when there's movement.
Well, that brings the total up to, I think, 170 or so folks that have had file transfer, which is great. Well over half, and we are moving forward. Now, one thing I noticed in the group, Greg, this is great, Jess, you're going to love this. They're not in chronological order.
Yeah.
They're not. Right. This is going to be so good when we file for discovery in this case. So, Jess, where are we? Jess is kind of our lead out on this with the court. Where are we? Because a lot of people have never filed lawsuits. They don't understand. Why is it not resolved yet? You've sued.
Yeah.
Let us know where we are.
Right. So this is a different type of case. It's a class action. So you have to get a class certified, which means we would represent everyone who meets the definition, which is, people who filed on or before a certain date, and you're included in the group. So we had all of those 601As. And so the government is contesting the class certification. So we've traded barbs on that. And the motion is pending before the judge of whether the class will be certified. At the same time, the government has sought to stay all deadlines, including the one for class certification, while they file a motion to dismiss. And they're doing that. And at the same time, we're going through the motions and having to come up with a schedule. They call it a 26F conference, and then schedule 2 weeks later. So we're going to have that meeting with them tomorrow. We did meet with the government last week just on a couple of items, including we shared with them what we would like to see as part of a settlement with them. And they actually took it for granted, or not for granted. They took it.
They took it to our client.
They actually seemed like they were interested in learning what we wanted, and we discussed. We actually put it in writing after that. We discussed that we'd like work authorization while we wait. We'd like travel authorization perhaps while we wait. We want the processing times to come back to what they used to be, which was around 6 months, and we want a deferred action as well. So, I don't know if there's going to be settlement here. I don't know if there's going to be discovery here. And I don't know if there's going to be class certification here. But that's the type of, logistical part of litigation that goes on before you file decision. There's a lot of things between the start date and the end date. And it's a marathon and not a sprint. And so there's a lot of work to be done. And we'll continue to do it. At the same time, as Chuck and Greg just said, I mean, the government has gotten the message that things are not moving, or were not moving, and now they are. So let's hope that we win on multiple fronts.
Well, the government, generally speaking, USCIS is generally not in the business of rearranging the deck chairs on the Titanic. So when they transfer a case, it's generally because they have a place where work can get done. Now, if you look back historically at the 601A, which has been around since 2013, they initially did these in local offices, which is where a lot of 601s were historically done too with officers. They then moved them all to Nebraska. The idea being you have a specialized corps of examiners who do this work. Well, clearly they ran out of examiners. And honestly, it wouldn't surprise me, Greg, if they just retired, because what was it? Something like 70% of the federal workforce is over 50 or something like that. So
Yeah,
it's
depressing.
it's a serious problem, right? All these boomers and Gen Xers are retiring from the government, and they don't want to keep doing these cases. So, they probably haven't,
They can just let AI make the decisions, and then they don't need people.
But they, it's funny though. But they didn't. When they oppose class certification, though, I mean, they didn't say that, hey, we're having a difficult time with retirements. They said there's this thing, there was a pandemic, and it's kind of, they just trotted out the playbook that we've seen in a number of other cases. So
there was a pandemic.
Yeah, like it only hit Nebraska and Potomac.
Not working.
Well, they've also, they've made these applications so much harder for the examiners to actually adjudicate, as far as the load on the forms and it takes a lot longer to actually work through these applications. I think their jobs are actually just harder, and a lot of people are probably burning out.
Yeah.
Oh, there's no question. But at the same time, people, I always make the kind of analogy to a restaurant. If you go in there and you order food and you pay in advance, and you sit there and then it's like midnight and you ordered 12 hours earlier, it's like, what, you paid in advance, and except it's far more damaging for these families because they're sitting there and they can't work. So if you're going to
leave a Google review on USCIS, can you?
Yeah. If you're going to do all this, that's why we've put out there a menu of options. Let these good folks work. Let these families support themselves while you take your sweet time. Again, we need to be forward thinking, and the agency is so backwards thinking in how they treat the immigration system. They're not helping themselves.
Yeah.
Well, there's an interesting piece of statistical information that came out. I'm still looking for the 601A stuff, but every month the USCIS is required to report to Congress on how many cases that they worked in certain areas. These are I-130s. Everybody's done an I-130 and 601A. 360s, SIJ cases, battered spouse cases, 485s. For the first time that I can remember, they actually adjudicated more I-130s than they received in that quarter by 1,000. So now the backlog is only 1.9 million for I-130s.
Catching up.
If they catch up 2,000 every quarter, they'll be caught up in never.
Yeah.
They'll be caught up in never. So, hey, at least, they as a practicing lawyer, I'm seeing a lot more I-130s, seeing a lot more 45s faster. But it's interesting because we have one website that a Facebook page that I'm part of, Dreamers Together, which is a group that does green cards for DACA kids through marriage, basically. And there, guys, I filed my I-130 45 for my spouse who traveled, and I filed it on Monday, and on Thursday I got my EAD. I said, wait a second, you can't be publishing that because that's not normal. It's not normal. And so the 601s will eventually get there. It's only a matter of time. But right now, what we're still waiting for is the last quarter's numbers on 601s. Kind of see what they did. But Jess, we have a meeting tomorrow. We'll know more. We'll send it once we have more information about certain schedules, timing. We'll send an email out to our clients so they'll know what's going on. And of course, we always update it here on our Facebook page.
Yeah, the takeaway is that the government is reluctantly meeting with us because the judge has not ruled on their motion to basically pause the proceedings while they try to move to dismiss. And so
that's not how motions to dismiss work. Jesse, you work for the government. Do you have to wait until the 60th day to file a motion to dismiss, or can you file it whenever you want to?
We also believe we know no wrong, so we just kind of do what we want until we're told not to. So that's why we have judges, I guess. And Judge Lynn is going to have to make a lot of preliminary decisions. So
we got a good judge. I'm very excited about our judge, and we'll go from there. So that'll be our update for today. Now, I do want to mention, of course, our 601 waiver application process. We're still onboarding for that. We need more plaintiffs. So if there's Facebook,
we will. That's going to be picking up in the next couple of days.
It's super important to to distinguish how we're doing the 601 cases from the 601A case. 601A case is a class action, major lawsuit. We're taking a different strategy with the 601s. We're going to do it like almost like a train that leaves the station every 20 minutes. I'm stealing that from Aaron, who's not with us today. But we feel like we can go in and strike on some of these that have been really out there on processing times and take care of them in a very quick and short manner. Here's 10 plaintiffs, here's 10 clients, they're all waiting here. So we're going to be taking a very kind of strike force type attitude, filing multiple complaints for those that sign up. So we're going to roll that out soon, or it's just a matter of people signing up and
we have we're not that far off from having the first group ready, but it'll be soon.
But I mean, the work in terms of the complaint, I know that we've worked on it and it's ready to go, and so we're ready.
So there we go. There's that. But join us, because nothing's better than suing the government. Now, again, these are for people who are outside the country waiting.
Right.
These are not
immigrant visa applicants processing at consulates.
Yeah.
And where did those times scream up to? They're past 32, right?
Oh, well,
2 years?
At least 2 years.
Yeah, I know the ones at CJ.
It's around the same neighborhood as the 601As.
But what's crazy is those they have family separation. I mean, they are. I mean, that's irreparable harm, as the that phrase is used.
27 and a half months at the Nebraska Service Center. Your other choice, because field offices can do these. I mean, they do them on.
I wanted to. I know we're kind of going in order on cases, but there have been some developments in the last couple of days at the agency that just kind of tell me that there are tools at their disposal where they can do a lot of things that they in the past said that they couldn't do.
Give us an agency update, Greg.
Well, one on the one I find fascinating is this group of 25,000 Ukrainians that came at the southwest border before the Uniting for Ukraine program. And they came in on 1 year paroles when they came in, and they are all coming due right now. And so it's like there's been a panic. We were told in January, some of the advocates working on this, that their agency had something, they were working on something. And we just found out yesterday what that was. They are going in working with CBP, and are going to advance the I-94s for a year for all of these people themselves. So no applications.
Nothing to do.
There's nothing to do.
I have been contacted by large groups who wanted to sue over this. I said, hold on. They're not going to do something.
That's amazing on there. I'm so happy that they did that. They're doing that proactively. Now, hopefully they're doing it correctly, but they're doing it proactively. Part two of that is they are automatically extending employment authorization as well without an application. Now, what they do say is that they are going to send out I-797C receipt notices to all these people, which will be evidence of, or I don't know if it's a receipt, but just some kind of document on it
that verifies the 1 year eligibility.
Verifies that they get a 1 year extension on their employment authorization. Again, no application is necessary, and it's automatic on there. I mean, there's just like I can't remember the agency doing that before. Maybe I'm like maybe there have been instances and I just don't recall. But that's what I want. That's what we want to see. We want to see, USCIS with the can-do attitude, which they're showing with the Ukrainians, and well, at least with this group of Ukrainians. Obviously, we're litigating on a different issue, which we'll talk about, I guess, in a second. But that is, that's the kind of stuff that they should be doing as well for this, for the 601As and others, that they can just be proactively solving problems rather than fighting in court on things.
I guess the one thing that frustrates me about this this issue, because it's these people have been really upset about this for months, and they waited literally to the last day. I mean, it's now that when the parole started.
They should have given a hint about what they were.
Yeah, I mean, really, what is the hide the ball?
The communications are horrible.
No,
on there. They have been. That's part of their problem, that they make their problems worse with just not communicating with the public, not communicating with the immigration bar.
Well, they don't even communicate with their own employees is another problem. I mean, that's there. All right, so I want to update everybody on our EB5 Jane litigation. Last night or yesterday afternoon, we filed our Rule 56D, motion for discovery, or extension of time to file a response to the motion for summary judgment. Our 26-page response and the exhibits are being emailed out, right, Greg, to our plaintiffs. So you'll get that in your inbox. What's important about this is that the government basically said, there's no controversy here. First in, first out, first in, first out. And thanks to our good friend, Matt Galati, who's kind of co-counsel with us on these cases, Matt had a fellow on Telegram, apparently, Jessica can maybe add more on this, who ran an algorithm. This is Greg Siskin-esque level tech savvy, where he, without having the case numbers, he figured out how to create a case number algorithm, put it into the system, identify the 526s, identify the filing date, and identify the last action. And he found that immigration had adjudicated 423 526s after the last of our plaintiffs had filed. So that means they took 423 people out of order. They didn't say this to the judge in their motion for summary judgment. Mm-hmm. Oops. So I think that alone gets us discovery. Mm-hmm. And with discovery comes adjudication, because they don't have a legitimate basis to say what they're saying, because they're literally not taking cases in order.
Yeah.
So,
and a lot of times in discovery, I think probably one of our most high-profile successes was the Milligan case.
Yes.
And that was due to discovery in a DV case where we found a smoking gun about a whole other issue.
Yeah.
But you never know what you're going to find in discovery.
And that's the reason why, these cases, when they are successful, whether, we had one H4 L2 spouses, that was one case. I mean, that was a thing I did privately. And, but the delay cases, I actually was listening to something yesterday and people were like, oh, you can't get this. It's an APA case. It's only record review. And I'm like, whoa.
Nelly.
The whole push of delay litigation is going to be, it's an opportunity to actually get discovery. And I feel like everyone needs to understand, like, it cannot be take the government's word for it anymore. And judges have been led to believe that you could. And what we're doing in some of these mass delay cases is showing that what they say, even on their own website, because they always cite to their own website or they cite to like a report. It's just not true. And it's incredibly important. And, the Jane case is going to be a good test, because on summary judgment, usually what you're saying is there's no disputed facts. And here we're showing that, in fact, it very well are disputed facts. And, and I give you guys a ton of credit. I'm not on that case, but it's a very important case in the EB5 world. And I'm going to argue a case in DC in the Circuit Courts of Appeals, because they're kicking a lot of these delay cases out at a motion to dismiss stage, because they're saying, hey, the government told us they're doing everything in order. It's all good. Don't worry about it. They do a visa availability approach. That sounds pretty good to us. I mean, they might as well just start making them up and saying, hey, we're doing the quick processing time. That's how we do things. It sounds good. But, the reality is so much different. And, again, I think that, going back to the 601A case and the 601 cases, this is where litigation will take a peek behind the curtain for once, for everyone out there who it doesn't have to live and say, I don't know what they're doing. Like, how do they do things?
Well, all we asked for was a deposition of the head of the investor program.
Oh, that's it?
That's it. Well, that and a couple questions we had answered. So
they'll settle well before that happens. I mean, the best thing is too, like, I can tell you right now, whoever you have left, either you're going to have to amend the complaint and add more people, or they're going to just take care of them.
Well, they've only done 2 of our plaintiffs out of the 15. So, it's interesting.
Yeah.
So
I will be interested. It'll be interesting to see, like, if the judge were to grant it, how quickly you become, the case becomes moot.
It's fun, because when we initially started the case, talking to the government counsel, is a local counsel, she's a, I said, maybe you get your client and maybe I can get them to just adjudicate these cases. I told her, I don't think that's good. I don't think it's gonna.
I will say this, and again, I rarely talk about my own personal cases, but I had a kid who was a graduate out in Chicago, and he really needed the 526 to be adjudicated. He was a Turkish national. Things had gone haywire. Just graduated, had a 526. Processing times had gone from 19 months to the moon.
Yeah.
We filed, and they adjudicated it in 2 weeks after we filed the complaint, which I thought was amazing because I'm in DC. You're totally different.
Well, it just depends on how strong is the U.S. attorney that says, I don't care what you have to do.
Exactly.
I'm not going in front of a federal court judge on this case. I'm not.
That was me.
Yeah.
I'll tell you, I know colleagues like that. I've told the story before. I had 200 Mandamus cases when I started at DOJ, and my boss, when I was a rookie, my boss came into my office and said, see all those cases? You're not going to do one of those. You're going to spend your time on doing those things, which at the time was some of it was like EB5 fraud. Some of it was NSEERS back in the day. And a lot of it were petition for removal cases in the circuit courts. But I never litigated a Mandamus case. And when I left the department, I wouldn't have known how to do it because I never did.
Because they adjudicated the cases. They were just, okay.
Oh, absolutely. Those are awful cases because the exit ramp is right there.
Yep.
Mhm.
All right, we have to do this. Hold your breath. There is no news on the Gomez Acker DB 2021 20 guys.
We're losing in the betting.
Because it's not April yet. All right. So yeah, we don't have a secret message. It's like somebody texted me, have you heard anything? No.
Why didn't we submit a premium processing request
exactly
to get the judges to decide quicker?
I just had to do that. Now, one piece of news that you all might not be aware of, we've talked about the H-1B lottery, which ends the 7th, was it Thursday or Friday at noon or something like that?
Mm-hmm.
I filed a lawsuit last Thursday on a FOIA. So I filed a FOIA in November for the data. And I just asked for three things. I just said, what number of employers were notified that they won the lottery? And of those, how many actually filed an H-1B? That was one. Next question was, how many H-1Bs have you actually adjudicated as of the day you respond to this for this fiscal year? And number three, how many have pending? That's all I asked. I mean, this is data that that they have. I mean, they don't have to go search for this. They don't have to create an algorithm. They know exactly what this number is. Well, I waited until January. Said you didn't respond within 20 days. So I appealed. I did the FOIA appeal. And they just wrote back and said, you don't have to appeal. You can just sue.
No way.
Yeah. So I sued. So
hold on. They said you don't have to appeal. You just sue us.
Charles H. Cook v. USCIS. FOIA
I'll tell you, attorney fees are very favorable in FOIA cases.
Yeah, except you can't get attorney fees. A lawyer filing for stuff he wants cannot. Is actually 11th Circuit case on this. You can't get your fees. But I don't care because literally it took me 20 minutes to put the pieces together and $410 to file it.
So you just filed it in Northern District of Georgia?
Northern District of Georgia. Just filed Northern District of Georgia. Now, it was a pain to actually do the filing because I screwed something up. But yeah. So now my TikTok, 60 days. I'm sure the U.S. attorney is going to get this and go, they didn't respond. And
it's so frustrating.
I am number 158 of 185 requests in whatever category they stuck me in. I'm sure they're going to say, Judge, we do these in order. And my answer is 20 days, Judge. 20 days.
Yeah, it doesn't matter if you do it in order.
That's the law.
Statutory mandate. 20 days.
If I were the judge, I'd be like, okay, well, all the ones where you're breaking the deadline, they have to be done too.
Yeah, there you go. Well, there's a great case out of the Ninth Circuit from back in the 80s, maybe early 90s, I think late 80s, where there was at least at some point a permanent injunction against INS to respond in 10 days to FOIAs. And when I was in Arizona at the time, we got all our FOIAs in 10 days.
I told you about the Muhammad global entry litigation.
Yeah.
That's like my only time I've been involved with FOIA litigation on that kind of issue.
Yeah.
And that was amazing how but that one they settled. I mean, we filed the case, and they basically within a few days they were back with us with what we were asking for.
Yeah. So we got that. So that's pending, and I'll let you know how that
You're going to hear
goes.
from them very quickly.
The government has until May to respond. I can't wait to hear back on that. Hey, let's take some questions here. We've got a few questions. Up to the top here. Alcis says, good news for everybody in the 601A. Yes, we did that early on. Aquí puntual una vez más. Saludos a Leonel, que chévere. Gustavo says hello. And of course, is Go Case still alive? I knew that. It had to be there somewhere. Where did Greg go?
Jesse, he was kind of like George Costanza. Everyone was saying good things, and Greg was like, "That's it, I'm out of here."
How long do you think the 601A lawsuit will be going on? Well, it's going to go a long while. The bigger question is, when are you going to get approved? And that's really the bigger question. Yeah. So, I think Jesse gave a really good outline earlier. Lawsuits. Remember, the government has 60 days to respond or file a motion to dismiss. That resets deadlines. More briefing has to do. Clearly, in my opinion, this is only my opinion, does not reflect the views of my co-panelists or co-litigants here. The government's trying to buy time. They know they're screwed here. They know they screwed up. They know they can't just not litigate case. They know this. Yeah. Well, there's at least one person there that knows this.
It is interesting. I mean, so we've had about I guess about 2/3 of the cases have been transferred, and about a third haven't. And I'm like, what's your prediction as far as whether is that going to, are they like done with the transfers?
Well,
or anything?
Before I answer that question, Jesse, when is the 60th day? Do you recall?
I do recall. I think it's 3/27.
All right. So here's my prediction, Greg. Every case will be transferred by 3/27, so they can file the motion to dismiss. Say, Judge, we're working these cases.
Yeah,
or they'll try something shady, like trying to get them to break it up and force us to sue them in every one of these local offices where they.
Well, that's what they threatened us with, by the way, is they separate out the case, go to Overlook Office, which is ridiculous because that's contrary to what the law would say. Because we could just go to Nebraska and sue, right? So
it's a class.
It's a class. The judge is not going to break this.
I think the way this is going to go is it's not about when, it's about at what step are we likely to see a settlement, and or perhaps it'll go the other way. If we get a class certified and the judge grants us discovery, the chances that's going to be directly related to our chances for settlement.
By the way, there is one reason why the government would be really stupid if they tried to push all these cases into the local offices. In Chakrabarty, there was a deadline.
Right.
And the reason why that was so successful for the government was it was the luckiest day that all these people ever had, because it was done like the day before the deadline, and there was no way physically or logistically that we could fight all those cases in all these places. We don't have that problem with the 601As. So if they get transferred to a lot of locations, that's just going to create a huge amount of work for the government.
Oh my God, think about the workload.
They have to. I mean, we will find local counsel in all these places, and we will litigate wherever. If that happened,
that would be insane for them to try to transfer to local offices. It's the judge would call them right out on that. They can't do that.
Right. I get that. Even if they were successful, the amount of work that would create. For the
hold on, but this would be their logic, though. This would be their logic, and I'd love to see them trot themselves into a courtroom.
I hope somebody's watching, because they probably don't even understand that was the difference in these cases.
If I file a lawsuit in Massachusetts and the case is in Massachusetts at the time, the government can just move it to Florida, and now I have to do it in Florida because you say so. Good luck with that argument, because I think a judge will absolutely lose it. Like, there's no way.
Right. But there's no way even if they had a sympathetic judge, and they did the same kind of thing that happened in Chakrabarty, the whole reason why we couldn't fight in those cases is because we had 48 hours.
But keep in mind, but we still filed like a half a dozen or more of them.
And they adjudicated those cases. Those cases got approved. The ones that we were able to do that.
I hope that it doesn't get
They're not
nasty like that.
If we had one more week in Chakrabarty, every one of those clients would have been approved, because we would have filed PIs in every location.
That's right. Right. So it was if that's it, the sort of the gleeful tone that the DOJ lawyer had when he mentioned that they might, they were considering something like that. It's like, dude, you don't even, if you knew immigration law, you would know that was a one-off, that's not going to happen again, because we would have the time to be able to fight on all of these, and which means that if they send it to 50 offices, that means 50 of your colleagues now have to defend these cases.
Yeah.
This is why I should never take the phone. Like when we're doing these, because I can't even hide. I can't. I should never do like Zooms or like WebEx when I'm on these like conference calls with them, because number one, I like them. I don't want to be nasty about it. But like oh my God, I was like, come on, like we're not going to do that.
I thought you were going to applaud me for keeping my mouth shut most of that call.
I know. You were good. You were very good. I'm trying to give the microphone to someone else tomorrow. No one wants to take it right now.
Well, I'm happy to do it, but you might not like the results.
It's okay.
Hey, by the way, Greg, nice beard. 61s we talked about. Updated 61. We've already got that. We've updated that already. Gustavo got his. Hey, case transferred to new officer's jurisdiction. The case was in Nebraska. Really, I think the simple answer is they do have a greater capacity in Potomac, is my guess. And they're going to go to the judge and say, Judge, this is what I think they're doing. We're putting them where we can do the cases the fastest. Now, what's going to strike against that argument is some people were moved a month ago. Have you done those cases?
Yeah.
That's a great judge. How many have they done? No.
Well, see, this is the other thing, though. How do you come in and say that you had a rule of reason if you've just changed the rule?
Well, that's a great argument. Bruno, great question, Bruno. So if the government files a motion to dismiss, we have technically 14 days to respond to that, Jesse, if I'm not mistaken. Yeah. And we can respond faster. And then the government has 1 week to respond after we respond. Mm-hmm. And when you file a motion to dismiss in this court, you actually have to set a hearing. You have to go into the court's calendar. You have to find the next hearing date and set that hearing. So the hearing is actually set. So for example, in the Jane case, I had to set a hearing on my rule, and the first available date on the judge's calendar was April 24th for our Rule 56 hearing. Yeah, that's 6 weeks away, but the briefing is going to be done in the next 3 weeks. But the judge just had X number of hearings on X number of days we have to take. So that's what I would suspect. Now, I don't think we're going to get the discovery in the X01 case. They're gonna settle because they do not want us deposing examiners and the service center directors and the field office directors, because we've got plenty of lawyers who do lots of depositions all at one time all over the country, and I'm happy to do that. The government does seem hell-bent on going in person, don't they, Jesse, to a hearing?
Seattle is kind of a beautiful place. Seattle's awesome. If I were them, I would say it. If they think they can get a competitive advantage by being in person and us being remote, I wouldn't take a position. I don't know why we're playing that game either, but yeah, I don't know.
Well, if needs be, I'd love to fly to Seattle on a day's notice. Not a problem. Rachel, you want to tell us the movement to Potomac? Again, we talked a little bit about that, Rachel. Timeline for 751s. ROC. I don't know what ROC means.
Rate of change?
Rate of change.
I don't know.
Forever. That's why immigration just extended 751 receipt notices.
Well, I will say this. I've litigated some I-751s. I think there's a statutory deadline. And I think you can actually get very positive.
Great case to litigate on.
Yeah, they're great cases to litigate. Every one of my clients who've worked with me on that have received a 751 real quick, and then you can kind of tie it into the Nats too. Yeah,
I usually have a Nats case pending at the same time. So
yeah,
751s right now are taking almost 3 years, but that's why they issued a rule that said, hey, those receipt notices that used to be for 18 months, they're now good for 4 years.
Yeah, I know, but that's so crazy because the statute. But they're just trying to fool you into thinking. It's like, here, take these drugs, you'll be fine. Wait a minute though. I want to get healthy. Like what? Like give me my case, give me my approval.
Well, the thing is, their delay is costing you citizenship.
That's 100%.
Yeah, 100% of the time. So
which is also curious because this one of the real bright spots for this administration on immigration has been naturalizations and citizenship. They clearly have made that a priority of getting more people, back to reasonable times and getting more people naturalized. So they're hurting themselves as far as that trying to achieve that objective. by taking so long.
Well, and the other thing too is, what they do is for the 751s that stay there and forever, they have to update. They have to issue an RFE some of the time because the information is stale, and so it actually creates problems for themselves. I mean,
Jesse, I've had people come into me with pending cases from 2012 recently. 2012. They've been divorced for a decade.
Yeah,
but here's what the regulation says: the director. 751s must either waive the requirement for the interview or arrange for an interview within 90 days of the petition being filed.
Yeah. I mean, good luck.
Day 91, you call us.
Yeah.
Be there. Sue the bastard. Yeah. Okay.
Have they ever waived? I mean, do they waive interviews on the
No, they just send you on receipt. They ignore that part of the regulation.
Okay.
They ignore it. All right, good morning. What's a good contact name for the case? I emailed and haven't gotten an answer for a concern. You should, if you registered in the 601A case, Mariela, there's an email there that you can email to in the registration. So, or you can just email Greg.
Well, we have so I mean, there's a form on the IMMPact website to do that, and then basically just to sort of like tell a little bit how it works on our end. So when people send inquiries in, if it's sort of an administrative thing, that it's not sort of a legal question, they're just asking sort of a logistical, something like that. But anyway, it comes in initially to Anna Carson at my firm, who then will send it to the appropriate person who's working on that case, or somebody, one of the lawyers after that, if there's a question that requires a lawyer, she'll forward it on. But if that she does get those and she does forward them, and the lawyers do answer them, so that's the best way to kind of control things. What we don't want is, like, we used to have this issue where somebody would send it out to every lawyer.
Every lawyer, yeah, that's good.
And then it was confusing as far as who should answer, or multiple people were answering, and then it was just like that was not efficient. And part of the reason why we, for these cases, we really have to get efficiencies in order for this to work itself out correctly. Yeah.
That said, none of us are hiding. All of us answer our emails. All right. So, thank you for the 601 update. Notified. Yeah. Well, we're going to file your lawsuit. So just stay tuned next couple of days. We hear back from us. Daniel's been waiting a whole 9 months. Well, hold on, Daniel, because they're taking 27 and a half. So you're a third of the way through your wait. That's why the litigation is so important. Are the ones not yet transferred, Greg, younger cases? I don't know. I don't think that's the case. I think the transfers are all over the board.
Yeah, I mean, it's actually, so we've had just a couple hours really since the last batch, and I can look actually and see. I'm just looking through the this most recent group. There was one that was filed in February 18th, 2020. March 4th, 2020, March 23rd, 2020.
I know in the first set of transfers, they transferred all over the board.
So this is interesting. So they all look like they, this first batch, they're February, March, here's May 2020. So May 2020, July 2020. So they're not,
they're not all in order. They're not.
Yeah, they're not in order, but it is interesting that they it's sort of like September 2020. Yeah. So yeah, that's interesting.
I know. I have to believe. I know they're going to file this motion to dismiss, and I don't want to get ahead of writing stuff on paper or whatever. I just find it really hard to believe that they are going to argue that they follow a rule of reason and they just change the process. And we can prove it. Like, I don't understand. Like, how does this work?
What's going to happen? I think what I fear is we will be so effective at using their online database that they're going to get rid of their online database. Nobody will be able to use it.
No. Well, here's the thing. I would just be like, listen, let's just have a real frank conversation. Like, if you've admitted that you've messed up and you neglected the cases, why don't we just settle instead of trying to play this game of who can trick the judge? Like, that is not a good game.
It doesn't help anybody. I never thought of myself as an Anthony Hopkins lookalike, but I'm thinking more Silence of the Lambs, rather than, maybe his other more popular movies. But I don't know. You never know.
There's a lot of compliments out there today.
Yeah,
on
I
the,
like
on
hearing
the
that. Gustavo, you received an email yesterday. New office. My case was in Nebraska. What do you think they're trying to do? I think you already asked that question, Gustavo. Jesse looks very good. There you go.
That cannot be true. I'm wearing, I think my mom gave me this sweater when I graduated high school.
One more t-shirt and you could be like Steve Bannon.
Well, you know what it is?
One
I'm
more
telling you right
shirt
now,
on.
we're having a blizzard and I'm trying to get to spring. So every day I start with a t-shirt, then I add a layer. By the end of the day, I'll have a hat on in my house because there'll be 17 inches of snow here.
Yeah, it is blizzarding in Boston.
Yeah, I know. I'm nothing if not different.
Ash, I sued. We'll give you an update in about 50 days. Greg, you look good too with your beard. You do. You just good.
I'm gonna get my Tsar Nicholas look going.
Is the transfer related to the demand? Yes, the transfer is related to the lawsuit.
No.
Alyssa loves my energy. Why is it so hard for judges to decide what does entry mean? All right. So this is actually a law school final exam question.
Yeah.
On one of my law school final exams. What does the word entry mean? Because entry no longer exists in immigration law. That word's gone.
Yeah.
Definitionally, it was erased in 1996 to be replaced with admission.
Yeah.
Yet admission uses the word entry in its very definition. So why is it so hard? Because it's very complicated stuff. It just is. I have DACA and I'm filing for 601A. Wait a second. Why are you filing for 601A, Kevin? Is your wife a citizen? Why aren't you getting an advanced parole and traveling and coming back in on getting a green card here? What are you doing? Travel. If you're married to a citizen, now she's a permanent resident, then you need to get her or him to become a citizen. You don't need a 601A. Don't waste your money and time. I haven't been working since 2018 because of all this process. Wow.
That sucks.
You know what? Everybody makes mistakes. That's why America is a country of second chances. At least we normally are. Any insights outside the United States? That's the lawsuit. That's our insight.
Yeah.
That's why you join our lawsuit.
Yeah.
All right. What kind of document Jesse Bless filed in court a few days ago related to the Gomez appeal? All right. That was an informational letter. I think it's called a 27J letter, Jesse. 28J. Just says, Judge, the letter the government sent you about that Supreme Court case, yeah, that's not true what they said. That's what Jesse said.
Yeah. I will say I think the government knew that case was not exactly on point, and what they want a decision too. So it's funny. I think both sides want the court to rule at this point. They want to know what's going on.
Yeah. So we're anxious too. I mean, the longer it goes, it just speaks that there's an issue with the judges.
Yeah.
Somebody's trying to sway somebody.
With one of them.
Equinox, F2K6. Yep. Lots. I mean, it's just terrible, the delays. Kevin, she is a citizen and really doesn't have a reason to do it. You don't need a reason to do advanced parole, Kevin. You don't need a reason.
Go see mom.
Go see your mom. Go see your.
Well, no, I mean, I get it. On DACA, they did have.
Yeah, I know, but
there are some. It's a little bit more restrictive than regular.
No, but you need to go down and see him. You need dental work. You need to go to a doctor. There's lots of reasons why you could do it.
Go take a class.
Honestly,
Chuck travels all the time. Go see Chuck in Panama.
You need to go on a business. There is a conference for pre-med students in Dominican Republic at Casa de Campo. They're going to a conference. Do it.
World Baseball Classic.
It's faster, cheaper, and easier than a 601A.
100%.
How long is the I-131 taking?
Oh, 2 to 4 months for DACA kids.
Okay.
Sometimes faster.
Okay.
Sometimes faster.
Dude, while you're here.
Yeah, I mean, it's faster than regular advanced paroles.
Well, if anything, it's just worth rolling the dice on getting.
Yeah.
I mean, if you get denied, then
100%.
I haven't been denied.
Have you seen an I-131 denied and a DACA kid?
Well, I saw in this group we had a couple denied. People filed themselves, but one or two lawyers maybe screwed it up. But it's you're going to get it approved. You're going to get it approved. All right, great to see everybody. Hopefully, Aaron's handsome face will be back next Tuesday. We'll see you guys then. I'll be live tomorrow at 1. Anybody else going live this week anytime? No? Greg has been speaking all over the United States in continuing legal education seminars for the last month. What do you 10 times, Greg?
Get a break for a couple weeks.
Get a break. Get a break.
Are you any of you going to be in DC next week for AILA thing?
Oh, John of Maine Bailey from our firm is going.
No,
All right.
I will not be in DC next week, unfortunately.
I will say hi to her. All right.
All right, you guys have a great week. Thank you, everybody, for joining us
good.
today.